I am Emily Buss, a faculty member at the law school, serving as the moderator for this series. One of the law school's important areas of academic research and clinical advocacy is policing and police reform. The goal of this series is to give our faculty the opportunity to share their work and to give our community the chance to discuss how these ideas relate to current efforts to reform policing. The sessions are designed to allow considerable time for questions that can inspire future research to address the issues that you help us to identify. This week's topic is policing and substantive criminal law, with a focus on over-criminalization and police defenses. Today's speakers are Professors Herschella Conyers and John Rappaport. By now, some of you are very familiar with our ground rules. I will introduce each speaker, after which the speaker will have roughly 12 minutes to speak. At approximately 12:30, we will turn to questions. Please send any questions you have and send them to me as soon as you have them by the chat function. I will do my best to ask as many of your questions as I can, with a focus on those most related to today's topic. I am pleased to begin today's discussion by introducing our first speaker, Herschella Conyers. Herschella is a clinical professor of law and the director of the Mandel Legal Aid Clinic's Criminal and Juvenile Justice Project. Before joining the law school, she served as deputy chief in the Office of the Cook County Public Defender. In addition to directing the clinic, Herschella teaches the Intensive Trial Practice Workshop and a seminar entitled Life and Death in the Law. Professor Conyers is also actively engaged in criminal and juvenile justice policy locally and nationally. She has most recently organized several symposia that brought together judges, educators, and other community leaders to discuss the criminal and juvenile justice systems and violence in minority communities. In 2013, Professor Conyers received the Edith Sampson Award from the Illinois Judicial Council for her work in advocating for young people in the legal system. A Chicago native, Professor Conyers received both her JD and her BA from the University of Chicago. Today, Herschella will focus on what over-policing looks like in communities of color in Chicago and how over-policing is fostered by non-police stakeholders. Welcome, Herschella.
Thank you, Emily. Good morning, good afternoon to everyone. I'm going to start by doing something that I am famous for, and that is stating the obvious. So here we go. We've heard these terms, mass incarceration and school to prison pipeline. Well, here's the thing. Both of those things start with over-policing in communities of color. And I want to give some history to this. So in the 1980s and 1990s, we had a war on drugs, we had a war on crime, and we had a narrative about super predators. Those things converged on the minority communities in Chicago and were devastating. And they were part and parcel of the over-policing of police in our neighborhoods. So when I talk about over-policing, I'm talking about two things. One, simply the number of police in any given area. And two, the practices. Once that overabundance of police presence of officers there, then the practices that are carried out in communities of color and in concentrated areas, even within communities of color. So again, let me say this if I didn't say it. Mass incarceration starts with over-policing. So what do we have in Chicago now? We have the South Side, which is much broader and richer, I think, than sort of publicly understood or nationally understood. There are pockets on the South Side of Chicago where the crime rates and the arrest rates are staggering. Also, the West Side. Again, a broader community, I think, than most people are aware of, but for today's conversation, I am talking about the West Side and South Side of Chicago, where the police presence is felt. Now, what I also want to talk about the practices, and these practices are pretextual traffic stops, group stops, Fourth Amendment violation stops, you empty your pockets, 4 or 5 teenagers lined up somewhere. And the presence not just only of the police in person, but the use of surveillance cameras in these communities are stunning. When they first started placing cameras in these communities, people started referring to these as blue light districts. And it became a sort of shorthand for poor minority communities. I see now that Hyde Park is fastly joining blue light communities, and the surveillance is much more widespread, but it is certainly more intense in minority communities and communities of color than in mixed communities and white communities. So all of those things have to be taken into account. And what is the impact of over-policing for the citizens in those neighborhoods? One of the impacts is simply an uneasiness when one sees a police officer, whether or not one is engaged in criminal conduct. The impact is teaching children at very early ages how they are to engage with a police presence in the community. And that's a hard, and I'll talk more about that later, but that's a hard thing to try to teach a child, to teach a young man about civic responsibility and also being wary of the police. And in most communities of color, those go hand in hand. And so how did we sort of do this? What are the pieces here? And because a lot of my practice is in the juvenile justice system, I do want to throw this in the mix. Again, in the 80s, as a result of the things that I have already mentioned, there was the creation and automatic transfers to adult court for kids as young as 13. So you've increased the population even eligible for incarceration, and you've increased the population that it's perceived needs to be over-policed. And the creation of these automatic transfers primarily were in drug cases, again, which accounts for the sort of empty your pockets. And anybody that had anything in their pockets was going to jail. And these were drug felonies. So there's a statute that has probably led to more felony convictions than any other in Cook County, and that is possession with intent to deliver. And when you are arrested and charged by the police with possession with intent to deliver, it is a felony. You add on there, if it's with intent to deliver within 1,000 feet of a school or 500 feet of a school, again, you can see the arrest and the seriousness of the charges mounting. Now, let me say this, to my knowledge, no white college student at the University of Chicago has been charged with a felony drug case. And it's my understanding, having been an undergraduate and a law student, there are lots of drugs on the University of Chicago campus, and this is not a sale offense. Intent to distribute means I share, whatever you call them nowadays, a blunt or a joint or whatever I have with my classmates and my dorm mates. These laws are not enforced in Hyde Park. And there was a study done when these laws first went into effect and these automatic transfers went into effect. In a year period, close to 400 juveniles were arrested and charged with felony offenses. Out of the, I believe it's somewhere like 393 kids that were arrested, there was one white child. that was arrested. And the sheriffs and police agencies in outlying counties in the suburbs openly said, we will not enforce this law. It was enforced again, only on the south and west side of the city. And what happens then is that the kids go to drug court and they are not going to prison. But once they are faced with adult prosecution and the possibility of prison, they will plead to one of the lesser felonies, and they are placed on probation, and they are then in the system. And what that means is that although they may not have served any prison time, they are strapped with felony convictions. And I'm sure that most of you are aware of the consequences of felony, of a felony conviction, and how it does not bode well for educational or economic future opportunities. And so I also would like to place in this, in 2015, there was the Chicago Police Accountability Task Force, which was commissioned by Mayor Emanuel. And at that time, the chair of that accountability task force was someone you all may know, up and coming lawyer named Lori Lightfoot. She had been with the city and worked with the city for a while. And that task force, I was part of one of the working committees for that task force, came up with some very unpleasant findings and received a lot of heat for it. But again, it was findings based on research, based on community outreach programs. There were public hearings held. There were lots of voices at that table. And this comes from their report. Chicago, as you may or may not know, is just about 1/3 white, 1/3 Black, 1/3 Hispanic. So it's sort of a nice little tripod of a city. But between 2008 and 2015, 404 people were shot by the Chicago Police Department. 404 people were shot. 74% of the people shot were African American. And what that means, I did the very sort of, basic math. 303 Black people were shot by the police in this 7-year span. And that's roughly 43 people a year, or over 3 people a month being shot by police officers. Again, when you place this in the context of concentrated neighborhoods, this is over-policing, and this creates, if not animosity, at least fear among law-abiding citizens living in those communities about what is going on and what is the position of the Chicago Police Department vis-a-vis communities of color. So again, that's not, in my mind, a small number. I can't imagine 3 people being shot by the police, 3 white people being shot by the police in Hyde Park. I find that absolutely incomprehensible. And there are no statistics that are comparable to that. So having painted that cheery picture, what I want to talk about now is, how is this? How is this that we have this over-policing even now, given the sort of historical birth of these wars, which by their very terminology imply and not a community together, but conquerors and losers and invaders, as opposed to folks working on things together. So part of the police defenses, and I think that Professor Rappaport will talk much more about this and certainly much more expertly about it than I am. But what I have seen as a 30+ year practitioner, these are the things that I see getting sort of in the way of making better policing choices. The union contract, the FOP is a world unto itself. That's the Fraternal Order of Police. That's a world unto itself. The union contracts, the qualified immunities embedded in those contracts have served to protect some folks who did not need to be protected and should not have been protected. And with that, this is where I talk about the other stakeholders in this, there is a lack of prosecution for perjured testimony by police officers. There is a lack of consequences for police misconduct when it is found. Historically, the police investigated themselves, which is usually not a good thing to happen. Again, historic lack of access to prior police complaints, so that you may have an officer on the stand who has done very similar, if not identical conduct, and you are limited in what you can present in a courtroom, even at a motion. I'm not talking about trials, but even in pretrial motions. The lack of access to these complaints. And again, we've come, a long way. The Invisible Institute has done some great work on making police misconduct of complaints and reports available by FOIA request, and that's a step in the right direction. So who else is responsible here? And I want to say again, it's the legislators, it's the state's attorney's offices, it's the judges that we elect in Cook County, and even defense attorneys. So that it becomes not just a question of immunity for police misconduct, but what I see is actually most police officers believing in an impunity, that their conduct is justified by their mandate to contain and control communities that they believe are criminalized, and that the ends justifies the means, and that there is some greater good going on here that will justify ignoring constitutional rights, ignoring their own oath of office in order to get the job done, and that the collateral damage of our judicial system not being trusted, and rightly so, in lots of circumstances, in way too many circumstances, in walking into a courtroom knowing that the test of credibility is not the same for police officers. They come with heightened credibility, which makes the sort of lying on the stand even that more egregious, but certainly makes the entire system less trustworthy. And so this, and I've been saying this for a while now, as we talk about these things, I want us to think about who we are in this. Because again, it's not like our police departments, they don't go to camp and stay in camp for 20 or 30 years. They come home to us. These are our fathers, our mothers, our sisters, our brothers, our cousins, our aunts and uncles, nieces and nephews. And they come home to us. So what are we telling them that says, welcome home, good job done? And what's the payoff for us in this? Because we are as collusive as anyone. We cannot talk about the police and the type of police departments we want outside of talking about ourselves and the society that we live. These are not strange, extraordinary humans. This is not a foreign occupation.
Rochelle, I want to interrupt we want to make sure we have lots of time for questions. So if I can ask you to maybe do a 30-second wrap up.
We need to think and talk more.
Okay, wonderful. Thank you, Herschella. And our next speaker is Professor John Rappaport. John is a professor of law and the Ludwig and Hilda Wolf Research Scholar. He studies criminal procedure and the criminal justice system. John graduated from Harvard Law School, after which he clerked for Judges Stephen Reinhart and Paul Watford of the Ninth Circuit Court of Appeals and Justice Ruth Bader Ginsburg of the United States Supreme Court. He also practiced in the Capital Habeas Unit of the Los Angeles Federal Public Defender's Office and at the Munger Tolles Law Firm before coming to the University of Chicago Law School. Much of John's current research focuses on policing and police misconduct, including the effects on police behavior of collective bargaining rights and unionization. Today, John will focus on the role of the substantive criminal law and criminal defenses in insulating police officers from criminal liability, and also on the role of criminal law as a regulatory mechanism for the police. Welcome, John.
Thanks, Emily, and thanks, Professor Conyers. As Emily says, I want to focus on the connection between the substantive criminal law and police accountability. I think it bookends nicely with some of the material that Professor Conyers brought up. The police are insulated from all kinds of accountability. They're insulated from civil accountability, political accountability, and also criminal law accountability. And I think that some of the things Professor Conyers mentioned, police unions, qualified immunity, these are hugely important factors in the overall picture of police accountability. But those tend to be, especially qualified immunity, tends to be something that serves to insulate police from civil liability in lawsuits. But again, I want to focus today on the possibility of criminal liability, criminal accountability for police officers who commit misconduct that also qualifies as a crime. And I think there's a nice way in which this bookends with Professor Conyers' topic. So one way to think about some of the material that she covered is the way in which substantive criminal law empowers police officers to over-police, right? If you have an increasing number of statutes that cover kind of inchoate conduct, criminalize inchoate conduct, like possession of burglary tools, or they make possession of drugs seem like a serious felony by calling it possession with intent to distribute. Or of course, famously, we have loitering laws and other kinds of public order defenses. The more criminal laws you pass, the bigger your criminal code becomes, the more the police are empowered to lawfully, if not rightfully, but to lawfully interact with people, stop people, right? I mean, there may be some police who are just stopping people with no cause whatsoever. And that's obviously a problem. But I think that a lot of people who study this area would tell you that no, actually, the thing is, most of the time, they do have some cause. And part of the reason for that is that the criminal code is so expansive. On the other end, we have these conversations about why is it that when police kill people, they're so often prosecuted for homicide. And when they assault people, they're so often not prosecuted for assault. Now, some of the explanations here are sort of political economic ones. So things like Professor Conyers mentioned, you know, we ask the police to police themselves, to investigate themselves. The district attorney, who might otherwise investigate the police, relies on that same police department to collect all the evidence for their cases. So there's sort of obvious incentive problems here in thinking that our ordinary system, where we rely on police and district attorneys to prosecute crimes, is going to work to hold police officers accountable for their crimes. But I want to talk about something even more targeted, and my criminal law students will be familiar with this material. I think even setting aside all of these other factors, all of these incentive problems, I think what a lot of people fail to realize is that the criminal law itself deems not criminal a huge amount of the police activity we see and we see on these videos that troubles us. This is partly because police officers, just like any of us, can rely on the self-defense justification, right? Homicide, killing somebody is not a crime if you did it in self-defense. And police officers, just like us, rely on this self-defense justification. And they're often the most important witnesses to the altercation that leads to the death, and they can sometimes shape the narrative. And even outside of self-defense cases, almost every state, I guess every state to my knowledge, has something in its criminal code called, law enforcement use of force defense, right? So the idea that law enforcement officers are justified in using force. It's not criminal for them to use force, including deadly force, in a certain set of circumstances. Now, a lot of people are familiar with the Supreme Court case called Tennessee versus Garner. Tennessee versus Garner is remembered for establishing the rule that the police cannot use deadly force against a fleeing felon unless they have probable cause to believe that that fleeing felon is basically a risk to themselves or to some other members of the public. But the thing about Tennessee versus Garner is that that's a Fourth Amendment case, and that deals with civil liability. That says that it violates someone's Fourth Amendment rights, and you can be sued for violating their Fourth Amendment rights if you use deadly force against them when they are fleeing a felony, if you have not established probable cause to believe that they're a danger to the community, okay? But just because it violates Fourth Amendment rights to use deadly force in those circumstances does not actually mean it's a crime to use deadly force in those circumstances. The question of whether it's a crime to use deadly force in those circumstances is a question of state law. And if a state wants to enact a very broad justification, defense in its criminal code for law enforcement officers to use force, it's entitled to do so. And those law enforcement officers, even if the prosecutors had all the right incentives and all the willpower to prosecute them, they may actually not have committed any crime as the state has defined it. So I think it's really important to understand this distinction, understand that Tennessee versus Garner is a case about civil liability, sets forth the circumstances in which you could bring a 1983 action and seek civil damages, but that in many cases, including Missouri, where Michael Brown was killed, the criminal code actually insulates police officers and says that much of the force they use is just not criminal, right? And so you see this sort of bookend effect with what Professor Conyers was talking about, where for ordinary people, we criminalize just about everything under the sun. And I don't think that's actually a huge exaggeration. But then when it comes to law enforcement officers, we give them special defenses in the criminal law, and those defenses can sweep even more broadly than the Fourth Amendment constitutional standard. The other thing I want to talk about briefly is, I think, a big sort of theoretical conceptual question about the extent to which criminal law is or should be a tool to regulate the police, to improve police behavior. And I think there's a lot of disagreement about this question, even within the left. One argument would be it's a deterrent, right? We want police officers to know that if they take a life, they will be prosecuted for homicide, and that will deter them from doing so. Well, our research on deterrence, and I realize this is a little bit circular here, but our research on deterrence suggests that if there's a pretty low likelihood that you're going to be prosecuted, even if the punishment would be great if you are prosecuted, it's not a great deterrent. And that actually much more of the value of deterrence relies on what we call swift and certain punishment, right? You get more deterrent power out of swift and certain punishment than you do about very uncertain and very severe punishment. And this raises a question, I think, about whether we should really expect the prospect of a homicide prosecution to be an effective deterrent for police misconduct. Again, I realize it's circular. If you prosecuted police officers way more often than you do now, then maybe it would become a deterrent. But in the world we live in, I think any particular prosecution of a police officer for assault or for homicide is probably adding only marginally to the deterrent value of the law. There's also an argument about the implications of these criminal prosecutions for whether we conceive of police reform as a project about individuals or as a project about a system. So some critics actually of using the criminal law as a tool of police regulation say that it falls into this trap of believing that there's just a few bad apples and we should go after the bad apples and we should go after them hard and we should put them in prison, and that's really going to make things better. And I think critics of that perspective would say, it's, this is a systemic problem, and picking off an officer here or there and putting them behind bars, it's not really going to change the system. I think perhaps the best argument for prosecuting police officers is the expressive one. And I think what's interesting about this question is that it makes you think hard about what is the criminal law really about? What are we trying to accomplish here? Are there reasons we might want to do it, even if we don't actually really believe it's going to reform the system to prosecute any particular officer? You might conclude, yes, it's worth doing it because of the expressive value of the prosecution, right? You could think of it as confirming for society the value of Black life, right? Some people would say, when you prosecute Derek Chauvin for killing George Floyd, you are expressing to the community that George Floyd's life matters. It matters as much as a white person's life. And we show that by trying to hold Derek Chauvin criminally accountable and send him to prison. But there's another segment within the left. I think it's really interesting to see how the left has divided on this. At least in my Twitter feed, my Facebook account is very divided between people who think we should go after these police officers hard because they're hurting people, they're hurting communities, and those who say, no, I'm an abolitionist, or I'm at least sympathetic with prison abolitionists. And though I understand the impulse, the desire to prosecute these police officers criminally, I think that's inconsistent with the broader message that I think we should be trying to send, which is that we should be decreasing our reliance on prison and criminal punishment as a tool for social reform. And so when a video like the killing of George Floyd comes out, my Facebook community was really split between people saying this officer, all four of these officers, frankly, better be held accountable, they better be prosecuted. And then people responding to those commenters saying, no, this is awful. I understand the impulse, but this is not the answer. Prison and prosecuting people is not the answer. And so I think that could be an interesting topic for discussion today. I'd be curious to hear what people who are watching think about that. But these are not simple questions, and they go to the very heart of what the criminal law is about and what function it serves in our society. I'll stop there.
Thanks, John. Maybe picking up there and picking up on one of our questions from people who are in attendance. Sort of question about the extent to which, if you stripped police of the kinds of defenses that you were identifying as standing in the way of prosecution, what do we know about the impact that's going to have on people who are willing to sign up for the job? And to get this idea that, is it right to assume that it's people who are up to no good who are going to be so happy these defenses are in place, or should we be concerned that conscientious, concerned police officers will be frightened of the risks associated with taking on a job if they are not protected by these defenses?
Professor Conyers, do you want to respond, or do you want me to?
I'm thinking of something, so keep talking. Yeah.
Okay. I think it's a legitimate concern. So this echoes a concern that you sometimes hear in the civil liability context, but there I think it's a lot less well-founded. So sometimes the argument about qualified immunity is if you stripped away qualified immunity, no one would ever want to be a police officer, because who can pay for all these judgments and settlements? And that's just a spurious argument, because police officers are always indemnified by the city or state they work for anyways. And so it would always be the government paying the bill at the end of the day and not the officer. Now, when you move over to the criminal context, it's different. If we're sending someone to prison, it's not the city or the state we're sending to prison, it's the officer. And so I think it's a legitimate concern. By the way, I mean, I never meant to suggest we should strip away these defenses, but we should think about, I think a lot of people don't even realize that their state's criminal law builds in defenses that are much broader than the Tennessee versus Garner standard. There's an article that I use in my criminal law class that makes this point. It's actually published in The Champion, which is a public defender magazine. And they say, you know, everyone's missing the point about the lack of prosecution to hold anyone accountable for Michael Brown's death. It's not a political failure. The criminal law actually probably immunized this conduct, right? And so that's, I mean to raise this question about the bounds of these defenses and whether we're aware of the bounds of these defenses in our communities and in our states, and whether we think that those bounds should extend more broadly than the protections of Tennessee versus Garner. I think there's a pretty good argument that, you know, you could roll back these defenses to the level of Tennessee versus Garner and not really affect the type of people that you'd be attracting to the profession. But sure, if you stripped away the defenses entirely and said any officer who injures somebody is going to be criminally prosecuted, of course, that would have tremendous effects on who would be willing to do the job or under what conditions. And so I think we need to be cognizant of that because, as I said, I think in a previous session, you know, we want to attract good people to policing, and how to do that is not always completely obvious. But we want to be careful about reform measures that might make it harder for, you know, good people to sign up for the job.
Priscilla, did you want to add anything on this point?
No.
Okay, all right.
Yeah.
So a number of questions sort of pick up in one way or another, and sort of thinking about the trial context, sort of assuming that there are charges brought, and this is, and I think there are questions that go both to when we have a defendant who is a police officer, and then some of the comments you made, Herschel, invited questions about sort of how we think about the testimony of police officers and the extent to which that can be constrained, or if that's the concern. And I wanted to start by sort of asking for some insight, maybe especially from you, Herschel, since you are a true trial attorney, and what are we, you know, what is the jury story here? I mean, you are saying that the police officer is a kind of a more effective witness, is sort of assumed to be more credible, therefore can get away. The suggestion is, therefore, among other things, maybe lying on the stand. What do we, you know, what are you seeing? What is your sense of juries? And is this changing with the sort of particular awareness and focus on issues concerning policing in recent months, years?
It's changing, but it's changing ever so slowly. And it goes to the notion, again, what I said is that these officers go home to someone. So one of the questions that is asked when you voir dire a jury is, would you believe the testimony of a police officer over that of a lay witness? Some people are honest and say yes. And then they are rehabilitated. But if I told you as the judge that you couldn't do that and you shouldn't do that, you wouldn't do that, would you? No, Your Honor, I wouldn't do that. So there's a lot of that. The other thing, though, that, and this may seem sort of far afield, but the officer shows up in uniform as a rule. And that in and of itself makes almost all of us have a different response to someone who is not in uniform. They are uniformed, they've got on their white shirts, they obviously don't show up in riot gear, the things that might scare us about the police, you won't see in the courtroom. The things that comfort us and make us feel secure, you will see. So they do have a leg up in that regard. But again, it's you know, the issue is who gets exempted, and this is where I say we are all sort of collusive. If there's going to be police testimony or whatever, you still then have the Batson issues that abound in jury trials that lead you to a jury that is more likely to believe a police officer than not, because there are going to be very few minority people on that jury, no matter what.
So can you say a little bit more about that? This is so let's say we're talking about a case in Cook County. Why is the jury going to be a majority white? Is that just?
I've asked myself that for 30 years, and I still have to, because the jury is going to be majority white. In any criminal case, now some misdemeanors, maybe not so much, but in a heater case, if you will, you're going to have a majority white jury. Some of it has to do with how we have historically selected jurors. Some of it has to do, and again, this goes back in some ways to over-policing. If you have a felony conviction, you're much less likely to serve on a jury. If you say that you would judge or that you believe that a police officer could tell a lie, you're going to get kicked either through a peremptory, and the judges try to rehabilitate potential jurors in different ways. Some they don't try to rehabilitate to excuse for cause. So it's part of the whole process that goes on in how we administer justice in the system.
I love the evidence question. So we got an evidence question of the extent to which prior complaints against police officers can be used to impeach police officers on the stand. So can be used, those kinds of reports come in to raise questions about the credibility of a police officer.
Yes.
Michelle, yeah.
To a limited extent, and it varies from jurisdiction to jurisdiction. In Illinois and Chicago, it's usually 3 years, and it is also usually, it has to almost track exactly the conduct that is being complained of at the current trial, so that all police misconduct is not deemed relevant at every trial. So you need someone to say, yeah, he beat me with his baton, not with a flashlight, but with a baton. I mean, they depending again on who's making these trial decisions, it can get that much in the weeds. The other issue, again, and I'm not knocking this as an evidence need, because I do feel the need for that, but you have to understand that people that are willing to come to court to talk about police abuse are usually people who have been charged with something. There's something at stake for them, and they are subject to impeachment if they have a prior criminal conviction. And that impeachment for them can go up to 10 years. So that, again, it's not quite the same as any witness in a case. Any prior conviction for you is 10 years. For a police officer, prior misconduct is 3.
Okay, thank you. So a big question, sort of thinking about if we're trying to address the mass incarceration problem, the question was framed as sort of what individuals are more of an impact, the police or prosecutors? And related to this, if we really want reform, and which target is likely to have more influence, prosecutors or police? They obviously collaborate in many ways. The question is sort of what could drive the change and what drives the problem of the two.
I'll start here, but I'd be interested in Professor Conyers' opinion as well. That's a very important, very well motivated, and very difficult question. I think there are dozens of books and probably hundreds of articles at this point about what led us to the place we're in right now, where we have over 2 million people incarcerated, and there's disagreement. There is a prominent account by John Pfaff, who's a law professor. He kind of points the finger at the prosecutors and says it was changes in prosecutorial behavior, a move to basically pursue more cases than in the past. In the past, they would have dropped more cases, let more things go, and they sort of upped the rate at which they were pursuing cases, and this was a big thing. And he was sort of provocatively said, it's not about the length of sentences. People think it's about the length of sentences, but it's not about that. Now, people have responded with very good critiques of his work and advanced their own theories that this is all about the length of sentences. So if the length of sentences is growing, even if police and prosecutors are just doing the same thing they've always been doing, putting exactly the same number of people, through the system, you would expect the prison population to grow because people are staying there for longer. So that's yet a third actor not raised in the question that we could be looking at sentencing commissions or the legislature that sets sentencing levels. I think it's so hard. I think if you're talking about mass incarceration specifically, I guess I would say, prosecutors, because they're ultimately the sort of the gatekeeper to the pursuing charges that can lead to incarceration. But police do lots of things that largely stays off the radar that are problematic, that affect people's lives, make people's lives worse, and don't necessarily directly contribute to people ending up in prison. And I think that shouldn't be discounted. So, if the question is, taking the question at face value, it's about mass incarceration, I guess probably prosecutors, but there are larger problems outside of just the total number of people in prison. And the police are obviously largely implicated in those. I don't know, do you have a view, Rochella?
Yeah, and it's very similar to what you've just stated. I think I would come out on that it's prosecutors. But here's the thing that I've been thinking about, and I'll give you one clear example. One of the things that Kim Foxx said that she was going to do was that she was going to raise the monetary amount on retail thefts, not by statute, but her office was going to make a policy decision that they were not going to prosecute felony thefts, retail thefts, for anything under, I think, $700 given inflation. The FOP came out strongly against her. They do not like this current state's attorney. And part of what I don't think people who don't practice understand is that lots of young prosecutors, one of their earliest assignments is what's called felony review. And what that means is that they go to police stations at all hours of the night or whatever. And they are there because the police have called them, but it is also a training ground where police officers train prosecutors. And they will say to a prosecutor, I know him, this one's a bad actor. Police try to convince prosecutors that they're human lie detectors, and so that they know when somebody's lying. And that sort of support for young lawyers and historically white privileged young lawyers going into the state's attorney's office, it's very seductive what the police do to prosecutors. And I don't think by the time they get to a felony courtroom that the romance is dead.
I got one question, and I sort of want to note that the questioner framed it with a concern that this might actually be perceived as a racist question. And I say this because I know that this is something that people consider a very sensitive question, which is this whole, sometimes called the silent majority question. Is it just a myth? Is there something to the idea that some victims of color want a strong and present and a greater police presence? Is that how is that's obviously something the questioner captured this that is perceived as reflecting something about one's underlying politics. I think the questioner was just like to get as much understanding as possible on that question.
I don't think, again, and I've been a defense lawyer all these many years, I don't get the sort of split between victim and perpetrator. Because today's victim is tomorrow's perpetrator and vice versa. So, and I think most African Americans, I think Hispanics, communities of color want effective policing in their neighborhoods. I don't think, so that I worry sometimes that when we create this sort of split, there aren't people out here that really hold as a political view, you know, gangs and indiscriminate shooting is the way we want to go. Just leave us alone and let us take care of this. That to me is just stunningly racist at a very sort of infantile level.
Can I jump in though? I think the question would be, okay, of course, that's understood, but what about whether a police presence, and maybe a strong police presence, is a helpful way of addressing that sort of clear problem that everybody would agree is a problem, or not? Or is that the wrong way to
I'll just say this, not if it's strongly doing the wrong thing when it's there.
Right, so what is the right thing?
The right thing is to be there when good things are going on. The right thing is to make police stations feel part of the community, as opposed to this is the last place I want to go. And just as a simple example, there's a huge police station on 71st and Cottage Grove. And there's lots wrong with that station, and it's manned mostly by African-American personnel and law enforcement officers. But I drove by there and there was a dance contest outside the police station. And I saw lots of people at the dance contest, young and old. So the notion of we only come out of the doors when we're after somebody is where I think the problem lies. I really think that it's a false argument that there's a split about a strong police presence. I think the discussion is, what does that mean?
John, did you want to add anything to this point?
I understand where the question is coming from. Whether or not there is actually a real split on the underlying question, the people who pontificate about these issues, the people in my Twitter feed, you know, policing Twitter or whatever, you know, my Twitter feed looks like, there sure is a split. And it's true that right now, certain people will jump on you if you sort of say anything about, like, what about crime? Like, aren't we worried about crime? Isn't crime harmful to communities too? And people will jump on you. But I think I largely agree with everything Herschella said. I think the more nuanced answer is people want to be safe, and safety can come about through a variety of mechanisms. I personally do not believe that we will, in my lifetime, arrive at a society where the police are entirely unnecessary. I think that is the utopian, vision of a lot of police abolitionists. It's if we have strong enough social services, good enough education, healthcare, all these other things that we won't need the police. I think that's too utopian for my taste. But I think the thrust of the argument is that there are other investments we can make to help reduce the problems of crime. Those will reduce our need to rely quite so heavily on the police to solve all our problems. The police might have a smaller footprint, and meanwhile, they should be doing things more like what Professor Conyers describes than the way they're doing it now. But I think, so I don't know whether that's a yes. There is a silent majority. Maybe it is in a way. I mean, there's a silent majority for we want to be safe. And there are people who I think are nervous, given discourse today, about saying, and I kind of think the police are part of that equation. There was an article in the Times just yesterday. It was called something like "Wary of the Police, but also of defunding them," or something like that. And it focused on Minneapolis. And the last line of the article talk about, Herschella started by saying she likes to state the obvious. The last line of the article, it was a quote from one of the residents that they had interviewed, said something like, good police are good, bad police are bad. And I think that captures a lot of it, right? So if the only choice is bad police, then maybe we want a lot less of it. But if we could have good police, then I think there are a lot of people who would want them there.
So I've got a question about the surveillance cameras and the question about what we know about the impact. And I think this somewhat ties in as sort of we think about how we change what is done. Is the surveillance camera idea always going to lead to a bad result? Is there a way in which it can actually be a beneficial part of a way of responding to crime? Do we know anything about change in crime statistics associated with areas with surveillance cameras?
I think it's hard to say. I mean, it's, I'm old school, so the notion of being watched by anybody gives me the creeps. But that said, I think that there is a legitimate place for surveillance cameras. We have seen them be effective in lots of ways. I will say I actually won a case with a surveillance camera. So that was the good news. I don't know why the police didn't see what I saw, but anyway. So I think they're here to stay, either way. And I think, again, if we look at it, crime has been down in the city and all across the city. And it's been going down. I don't know what to make of this summer spike, but I don't know what to make of 2020, so.
Yeah, I was trying to think if I've seen rigorous academic research on this question, and I can't think of any right now. Really sort of reliable papers showing whether something like surveillance, the addition of surveillance cameras affects crime rates. I haven't seen that. But there's a big sort of theoretical question at play here, which is the extent to which we want our police to be proactive versus responsive. You can imagine a world where the police are not proactive at all. They literally just sit in the station and wait for calls, right? And those calls are coming usually after somebody is hurt or something is stolen or some property is damaged, right? That would reduce one set of concerns about being surveilled, about being intimidated by the police, but I don't know that that's our ideal world. I think it'd be better if the police could stop a lot of crimes before they occur. But when you go too far in the other direction, then you basically are in a minority report, where the police are just saying, I know this guy, he's a bad guy, let's pick him up because he was probably going to do something bad. And I don't think we want to live in that world either. And I think we're trying to find this balance. I don't have a strong view about whether, cameras put us onto the wrong side of the balance or not. Although it's interesting, I know that Professor Conyers was maybe partly joking, but I actually am not that creeped out when I see cameras. I don't really care anymore. I'm sort of this view that like there's just so much information out there and so much footage and so much everything that I'm almost anonymous because there's too much to consume. Now, maybe I think that partly because I also don't think they're going to be searching through footage for people who look like me and whether they're doing suspicious things or try to pin something on me. So maybe I'm less worried about it than I would be if I lived in a different spot or looked different. But I'm actually sort of comfortable with the surveillance. Now, I don't look around at those cameras and think, oh, thank God those are there. They're keeping me safe. I just kind of don't really mind them either way. But
I know that Herschella was not joking because I'm on the same side of the generational divide and they creep me out too. But I do think there is something generational about that. And with that, we are out of time. I want to thank Herschella and John both so much for participating and all those of you who joined the discussion. Please join us again next week. It's our final session, and we'll hear from Will Bode and Craig Futterman, who will discuss civil lawsuits and qualified immunity, which many of you have had questions about throughout the series. So
thanks
much, and
thank you
see
guys
next
for
week.
coming. Take care, everyone.